Supreme Court dismissed the appeal in the matter of PRADEEP NIRANKARNATH Sharma versus the state of Gujarat and held that we find no merit in the present appeal and clarified that this order shall not preclude the appellant from availing any other remedies available to him under the law in respect of pending FIRs or future proceedings. The facts leading to present appeal were that the appellant was a retired Indian Administrative Services officer who served in various administrative capacities, including as the collector of Kutch district, Gujarat, between 2003 and 2006. Several FIRs have been registered against the appellant in connection with alleged irregularities in land allotment orders passed during his tenure as the collector. The allegations against the appellant primarily pertain to abuse of official position, corrupt practices, and financial irregularities in allotment of government land. It was pertinent to note that first FIR in this regard was registered in 2010, followed by successive FIRs lodged against the appellant. The appellant had remained in judicial custody over course of the period in connection with these cases and trials ongoing before competent courts. Aggrieved by registration of multiple FIRs, appellant approached the High Court of Gujarat by writ petition under Articles 14, 20, 21, 22, and 226 of the Constitution of India. The primary relief sought in writ petition was for issuance of writ of mandamus or any other appropriate writ order direction directing the respondent authorities to conduct preliminary inquiry before registering any further FIRs against him. The appellant contended that his fundamental rights, particularly his right to liberty under Article 21, were being violated due to successive and arbitrary registration of criminal cases without conducting preliminary inquiry. He further contended that these FIRs were lodged with ulterior motive to harass him and prevent him from effectively defending himself in pending cases. The legal position regarding registration of FIRs in case of cognizable offences, court said, is well settled. This court in Lalita Kumari case had categorically held that the registration of FIR is mandatory under Section 154 CrPC if the information discloses commission of a cognizable offence. The decision in Lalita Kumari case does not create an absolute rule that a preliminary inquiry must be conducted in every case before registration of FIR. Rather, it reaffirms the settled principle that the police authorities are obligated to register FIR when information received prima facie discloses a cognizable offence. The scope of preliminary inquiry, as clarified in said judgment, is limited to situations where information received does not prima facie disclose a cognizable offence but requires verification. However, in cases where the information clearly discloses cognizable offence, police have no discretion to conduct preliminary inquiry before registering FIR. In present case, allegations against appellant pertain to abuse of official position and corrupt practices while holding public office. Such allegations fall squarely within category of cognizable offences and there exists no legal requirement for preliminary inquiry before the registration of FIR in such cases. Appellant's contention that successive FIRs have been registered against him with ulterior motive is a matter that can be examined during course of investigation and trial. Appellant has adequate remedies under the law, including right to seek quashing of frivolous FIRs filed under Section 482 CrPC, the right to apply for bail, and right to challenge any illegal sections of investigating authorities before appropriate forum. Court said that it cannot issue blanket direction restraining the registration of FIRs against the appellant or mandating a preliminary inquiry in all future cases involving him. Such a direction would not only be contrary to statutory framework of CrPC but would also amount to judicial overreach. As rightly observed by High Court, courts cannot rewrite statutory provisions or introduce additional procedural safeguards that are not contemplated by law, said the Supreme Court.